The recording's been started.
Thank you.
Family of Babcock, Michelle. That's okay. Family of Babcock, Michelle.
So before we get into this too far, there's some housekeeping. I would like for everyone to mute their phone or Zoom or computer right now so that their audio does not come over unless you're speaking or being asked a question. Thanks a ton. I really appreciate that. We had some delays this morning because we wanted to change some of the audio around to make sure we got a good record, and I think that's been resolved. I don't think anyone on the outside will be affected by the decisions we made. First, we are now on the record for docket number CC-2021-OGR-01-001. It's now 9:21, Thursday, August 12th of 2021. We're at the Fruitland City Hall in Fruitland, Idaho. This is approximately the time set for the evidentiary hearing as provided in Idaho Code 47-328-3 for the spacing unit consisting of the southeast quarter of Section 10, southwest quarter of Section 11, northwest quarter of Section 14, and the northeast quarter of Section 15. Township 8 North, Range 5 West, Boise Meridian, Payette County, Idaho. My name is Nick Thomas. I'm the Division Administrator over Minerals, Navigable Waters, and Oil and Gas, presiding over and conducting this hearing today pursuant to Idaho Code 47-328. Some housekeeping. As many of you know, the COVID-19 response has changed some of the typical aspects of a hearing of this type. This hearing is in person with a virtual via Zoom component. We also have a call-in number that was sent out. This hearing is being recorded in Zoom as required by IDAPA 041101-651. We also have a backup recording device for this hearing. People who are in person will come to the podium and speak as needed. This hearing is being recorded by a court reporter, so I ask that everyone here be sure to speak loudly and clearly. Please limit side conversations. If you haven't done so already, please silence your cell phones. For those of you on Zoom, please mute your microphones when you are not speaking. If there is disturbance, you will be reminded to mute your microphone. If the disturbance continues, you may be muted or disconnected. Documents in this record, docket number CC-2021-OGR-01-001, are on the OGCC website at ogcc.idaho.gov/administrative-hearings. Exhibits and witness lists were submitted by Tuesday, August 10th at 5 p.m. We can also use the exhibits posted on the OGCC website to ensure that we are looking at the same documents. Please reference the exhibit number, page number by the PDF page number. The evidence on Zoom will be displayed by Mr. Chris Gozo, a member of my staff. Parties and witnesses should direct Mr. Gozo to each specific exhibit page they would like displayed at the time they would like it displayed. As my June 23rd, 2021 notice indicates, this hearing is to receive evidence and testimony regarding Snake River's March 26, 2021 integration application. I will use the factors articulated in my orders determining just and reasonable factors to determine whether the terms of an integration order fulfill the just and reasonable requirement of Idaho Code 47-321. The order determining just and reasonable factors was mailed to the operator and all uncommitted owners in the spacing unit on June 21st, 2021, and can also be found on the Idaho Department of Land's website. I would like to say that as of early morning, I did respond to the response from Mr. Piotrowski that Kaya be considered. Essentially, I denied that request, and for factors that were outlined in that, I believe everyone has been emailed that response. Just so you know there, Mr. Piotrowski, I think, is representing individual mineral interest owners in this case, so he'll continue to speak as he always would. But I have determined that Kaya cannot participate or object in that capacity. We'll proceed with opening statements from Snake River Oil and Gas, uncommitted owners within the unit, then the IDL. The opening comments will be limited for 5 minutes. Afterward, the hearing will follow. I will first hear evidence from the applicant, Snake River. This will be followed by evidence from uncommitted owners within the proposed unit. Afterward, I will accept evidence from the Idaho Department of Lands. After the presentation of evidence is complete, I will allow closing arguments. And then I will provide for recesses from time to time as needed. I have this hearing scheduled for all day today and tomorrow if we need it. If not, we'll use recesses as needed. And I will definitely, if we go into the lunch period, I'll have a 1-hour lunch recess at 12 o'clock. So moving into opening statements, Mr. Christian, you are at the podium. I may turn the monitor around a little bit to see you, but will you please identify yourself and who you represent, and feel free to have an opening statement.
Thank you, Mr. Administrator. I'm Michael Christian. I'm here representing the applicant, Snake River Oil and Gas LLC. I don't intend to give you a lengthy opening statement other than to say, would submit that the materials that we submitted as our application establish the elements necessary to integrate the spacing unit, and I anticipate putting on testimony mostly from Mr. Brown regarding the factors to be determined to establish that the form of lease and form of joint operating agreement submitted with the application materials contain just and reasonable terms and conditions of integration. I did at our pre-hearing conference raise the question of whether the parties could stipulate to what I called at the time entitlement to integration, by which I mean stipulate that the applicant has established the factors necessary to obtain an integration order, which would be essentially the sufficient percent leased in the spacing unit and a sufficient resume of efforts, and that the drill site has been leased. I've raised that again, and I have a witness, Mr. Moore, who can speak to the resume of efforts issue if necessary, but in an effort to save time, I'd ask the parties stipulate to that part when we get to the terms and conditions.
Thank you very much. Ms. Vega, do you have an opening statement? Okay, thank you.
No.
Okay, good. Thank you very much. Mr. Piotrowski, do you have any opening statements you'd like to share?
Excuse me. Yes, James Piotrowski here. The determination of factors in this case has already established that there is zero additional compensation to be made available to anybody, no matter what comes up at this hearing, no matter what decision is reached, no matter what might be just or reasonable. So there's very little to argue about here, except the fact that there is zero evidence offered to date, and there will be zero evidence offered today as to the actual market value of the leases that my clients will be forced into. And for that reason, the integration order should be denied.
Thank you. Are there any other uncommitted mineral interest owners who will be presenting today who would like to make an opening statement? Thank you all. In that case, we're going to begin with the applicant to provide testimony and call its first witness. I will offer the oath to the witnesses. Mr. Christian, do you swear or affirm that the testimony you will give at this hearing is the truth, the whole truth, and nothing but the truth?
I do, although I don't expect to give any testimony.
That's exactly right. You're a little football. Well, at least you're very honorable today. Thank you, Mr. Christian. You may proceed.
Yeah, thank you, Mr. Administrator. I'm going to call Mr. Brown first. Mr. Moore is traveling and I think is probably still in the rental car as we speak, so I'm going to go out of order as a consequence. So I'll call Richard Brown right now.
Thank you very much. Go ahead, Richard. You want water? I'll pour it for you. Thank you. No problem. Now, apologize for that. Mr. Brown, do you swear or affirm that the testimony you will give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Christian, you may proceed.
Richard, can you state your full name for the record, please?
Richard Wesley Brown.
And where do you live?
I live in Sun Valley, Idaho.
And, you're a partner in Weiser Brown Oil Company?
I am.
And is Weiser Brown Oil Company the sole member of Snake River Oil and Gas?
It is?
Yeah. You have, tell me what your background is.
I'm sorry to interrupt, but I'm having a difficult time hearing the witness. Is there a way to move the microphone closer to him?
Sit right over here. Take it back.
How's that?
Much better.
Go ahead.
Richard, can you give me a summary of your training and experience in the oil and gas business?
Yes, I have a degree in petroleum land management from the University of Texas. I went to work immediately out of school as a petroleum landman and have worked in that capacity for 40 plus years.
And in your capacity as a landman, you had experience negotiating things like leases and surface use agreements with mineral interest owners?
Yes, I have.
Is that true both in Idaho and in other states?
Yes.
What other states have you worked in?
I have worked in Texas, Louisiana, Oklahoma, Arkansas, Mississippi, Alabama, a little bit, tiny bit in Utah and Idaho.
Okay. And are you responsible for managing the day-to-day operations of Snake River here in Idaho, including its leasing and permitting efforts?
Yes.
And are you familiar with the integration application filed in this matter?
Yes, I am.
I want to direct you to what's been marked and submitted as Exhibit SR1, which is the integration application. Can you get that up in front of you?
The application itself.
Can you please look at Exhibit A to the application for me, which is,
Flat.
I'm going to comment, there are page numbers in the lower left-hand corner of the exhibit in red. So I'm looking at page number 9.
And that is the plat.
Okay. You have it in front of you?
I do.
And does that plat depict the spacing unit, which is the subject of this integration application?
Yes, it does.
And shaded in gray in the exhibit, are those the tracts which are currently uncommitted and are the subject of the integration application?
Yes, they are.
There is there not one tract in those that since the time of the application has been leased?
Correct.
And which owner is that?
The Mussers in track number 2.
Down in the lower left-hand corner in the northeast quarter of section 15.
Correct.
Is that right?
Correct.
Okay. Could you go to exhibit, well, let me stop. Do you have an understanding of how many net mineral interest acres in the unit are currently under lease?
90+%, and that number is, I'm having a senior moment here.
But it's in excess of 90%.
In excess of 90%, correct.
Okay. Could you move to exhibit C to the application in exhibit SR1, which begins at page number 14.
JOA?
Yes, can you identify that for me?
Yes, it's a model form operating agreement.
And describe for me generally what a joint operating agreement is and what its purpose is.
Joint operating agreement dictates typically for the working interest owners, who are the people that pay for the well, how they interact and how the well's operated, accounting, multiple topics, but basically it concerns the working interest owners and how they work together.
Generally speaking, it involves, among other things, how expenses and revenue associated with the well are dealt with.
Correct.
Okay. And in this instance, the form of joint operating agreement that's been submitted as part of the application is for the purpose of the event that an integrated mineral interest owner elects to participate in the well, right?
Correct.
And they might participate on a consenting basis or a non-consenting basis.
Correct.
Is the form of joint operating agreement that's Exhibit C to the application similar to the form that is used as between Snake River Oil and Gas and its working interest partners?
Yes.
And generally explain what working interest partners are in this case.
Yes.
They're basically investors?
Yes, and in this case, folks that we've dealt with for many, many years.
Okay. And Snake River acts as the operator in other units where you're already under operation on behalf of all of its working interest partners?
Correct.
Okay. There have been about 6 integrations in this area so far, is that right?
Correct.
And each of those integration proceedings has essentially the same form of joint operating agreement been used.
Yes, it has.
Some of those have been by the prior operator. And at that time, Snake River was a working interest partner, but was not the operator, correct?
Correct.
In any of those previous integrated units, has any integrated mineral owner elected to participate in the well yet?
No, they have not.
The form of joint operating agreement that is included as Exhibit C to the application is labeled as an AAPL Form 610, the 1989 version. Can you tell me what the AAPL is?
American Association of Petroleum Landmen.
And is Form 610 a form that you are familiar with in your work in the oil and gas business in other states?
Yes.
To your knowledge, how long has either this version of the Form 610 or earlier versions been in use in the industry?
Throughout my career, and I think this 610 came out in the 50s, and it's been updated 3 or 4 times since.
In your experience, is a version of the Form 610 used by most participants in the oil and gas industry across the country?
Yes.
Does Weiser Brown use a similar form in its operations in other states?
Yes, it does.
Roughly speaking, how many wells would you say Weiser Brown has been a party to this form in other states?
Probably at least 1,000.
To your knowledge, is the Form 610 adopted by any oil and gas governing body in other states?
I know the state of Arkansas uses this form, and I think other states, but not positive.
Is there anything about this unit which would lead you to conclude that using the proposed Form 610 would not be appropriate?
No.
Generally speaking, what is the reason for proposing this form of operating agreement for integrated mineral interest owners?
It puts the mineral interest owners on the same footing as the working interest partners and our partners in this area.
So your intent is that a mineral interest owner who elects can participate on the same basis as the existing working interest?
Correct.
There is in your form of joint operating agreement as between Snake River and its partners, the risk penalty is somewhat higher than in this form, isn't it?
Correct. And with our our internal partners, it's 500%, but in this, form here, it's 300%.
And that's just as a matter of a statutory cap?
I believe so.
Can you go to Exhibit D to the application, please?
Yes, I am there.
And is that the form of lease that's been proposed as part of the application?
Yes, it is.
And I'm sorry, I'm going to give a page reference for the record. I can get back to it. It is at page, I think, 69 of Exhibit SR1. Is this form of lease similar to other leases that are in use in the area?
Yes, it is.
And what's the bonus that's proposed to be paid for the integrated mineral interest owners?
$100 an acre.
And what's the royalty that's proposed to be paid?
1/8.
And what is the term that's proposed?
It's proposed as a 3-year term with a 3-year renewal option.
Are those terms similar to the same terms in voluntary leases across the area?
Yes, they are. Little longer term with the other leases in the area. We have some with 2-year and a 5-year option, and some with 3 and we have 3 and 5.
Do you have some with a 5-year term and say a 2 or 3 year option?
Excuse me, and when I said 2 and 5, 5-year primary term with a 2-year extension option.
Okay.
Yes.
Safe to say that the vast majority of the leases across the area, including in this unit, are at 1 acre royalty.
Correct.
In fact, is there any voluntary lease in this unit that's above an acre?
No, there is not.
The lease form, and Ms. Vega was kind enough to point this out to me, and I think Mr. Thumb did a previous, or filing in another proceeding. The lease form itself only refers to consideration of, $10 and other sufficient consideration. Is that language is fairly common in leases that are recorded?
Correct.
But in fact, the bonus that you're proposing to be paid for the applicant is $100 an acre.
Correct.
Plus, and $50 an acre for the renewal option.
Correct.
Is that $50 an acre consistent with the voluntary leases in the area?
Yes.
Are versions of this form of lease used in your operations in other states?
Yes, it
Is
is.
there a kind of a nickname for this kind of lease?
Producers 88 is one. There's multiple, but they're very, very similar.
Yeah. And how long have Producers 88 been around?
50+ years.
Is this form of lease in particular, is it consistent with the forms of lease that you have used in all the states that you've identified in your experience?
Very similar, and it was used in the earlier integrations.
Is the form of lease similar in its terms to other leases in this unit?
Yes.
If you look at beginning at page 72, is that some special terms and conditions that are attached to the lease?
Got it.
Does this lease have, in item 1 of the special terms and conditions on page 72, does it have a limitation on drilling activities?
Yes, it says we shall not engage in drilling operations on tracts less 5 acres or less.
Is that generally a term and condition that is included in other voluntary leases in the area?
Yes.
So some leases have got a drilling limitation that you've taken voluntarily? the lease also in item 1, does it, or elsewhere in Exhibit B to the lease, does it provide protections to surface owners for surface disturbances?
Yes, it does.
Can you summarize what those are?
Well, for instance, protects the owner regarding well sites, roads, fences, pipelines, or utilities, installation, production equipment, tank batteries, protect the water, and the landowner, and if anything, protects, let me see, number 2 is protection and use of water.
In item 1, does it require the lessee to pay the surface owner damages for any damage to various things, crops, buildings, livestock, those kinds of things?
Yes, it does.
Has Snake River as the operator or as a working interest partner under the prior operator experienced any problems with any lessors under a form of lease of this type in its operations?
No, we haven't.
And how long has either Snake River as the operator or as a working interest partner under the previous operator been involved in operations?
10 plus years.
About how many wells are producing right now?
As of, I think 4 wells are online today, at this very minute, but we've produced upwards of 6 or 7 over the course.
This may be a hard question to answer. Maybe a hard question to answer off the top of your head. Do you have a rough idea of how many leases, voluntary leases, have been involved in the units that you have produced so far?
100 plus, counting all the units.
Okay. Does this lease, this proposed form of lease, affect the right of owners who choose not to participate as an owner from exercising any private right of action against the operator for future harms?
No, it does not.
A couple of small items. One, going back to the lease, I think it's in item 1 of the lease itself. There is a spot where, there are 2 spots where a number of days is referenced, and you see it where it's written out as 90 and then 120 days in parentheses.
And are you in the addendum or are you in the body?
I'm in the lease itself.
Okay.
So I'm on page 69, item number 1.
Okey-doke. Got it?
So there are 2 places I see in that paragraph where the number is written out as 90 and then in parentheses is 120 days.
And mine says 120, but go ahead.
You see the word before the parentheses?
Ah, got it. Is
it the intent that the number should be 120 days?
Correct.
Okay, and going down to, apologize, let me get the reference correct here. Item number 8 on the same page. You see the setback language?
Yep.
And it uses the term 200 feet. Was the intent that should be 300 feet?
Correct.
And can the applicant submit a form of lease that corrects those 2 items for use and in order?
Yes, it can.
Okay. I don't have any other questions.
Thank you, Mr. Christian. In that case, Mr. Piotrowski, you may ask questions of the witness at this time.
Thank you. Mr. Brown, the model form operating agreement, am I correct in understanding that that only applies to individuals who choose to be working interest owners?
Correct.
And so for those who are either lessors or deemed leased, that document would not apply to their relationship with Snake River Oil and Gas, right?
I can't, I'm having a hard time hearing you. Apply to their relationship
apply to their relationship with Snake River Oil and Gas?
Yes, that is correct.
Mr. Pietrowski, Mr. Brown, stand by just a moment. I'm wondering if there's any way, since the phone only goes this far, you know what I'm talking about? You can, if you want to sit here, or is that working for you? Would that work a little better, or what do you want to do?
Yeah, that's what I.
Folks, I'm sorry about that.
Well, I am almost never accused of speaking too quietly, but I'll do my best to make sure the reporter can hear me.
I know, and I don't know if you're, can you go under participants? I'm kind of computer. Okay.
Probably that thing
Oh, you're
going into
good.
the microphone.
Okay, that's fine.
It's okay here. You want to move it down a little bit more?
I can't.
All right.
I can hear, I just, I think that would be better.
Okay, Mr. Pietrowski and Mr. Brown, thank you for your patience. You could start that again if you'd like.
Thank you. Mr. Brown, if I understand correctly, well, tell me if I understand correctly that for mineral owners who choose to enter into a lease or who through inaction become deemed leased, their relationship will be governed by the oil and gas lease and the attachments to it, appearing at pages 69 through 72 in Exhibit D. Is that right?
That is correct.
In that lease, other than the statement, and I'm looking at page 69 here of Exhibit SR1, there's a statement in the second paragraph that mentions consideration of $10. But in fact, that is not the consideration being paid pursuant to this lease. Why is the amount of consideration not included in the lease?
That's a good question, and I'm going to defer to Mike. Leases have been this way since I was in college, and it says $10 and other valuable consideration, good and valuable consideration, and a lawyer's going to have to answer that. But
to your
it's
knowledge,
been that way in business ever since I've been around. Some leases actually, go ahead.
and so this is ultimately this is a lease of mineral rights that are attached to real property, right?
Yes.
Okay. And so this is a contract that affects the owner's interest in their real property, correct?
No.
Yep.
Now, and that $100 bonus payment, I think we call it, that's not referenced anywhere in the lease or the attachments, right? Oh. Everything's gone silent on my end. I'm sorry, Mr. Thomas, or Mr. Brown, I'm not hearing anything from the hearing room, it seems.
Mick, we're not able to hear you here.
All right.
Okay, I think we've got you back.
You do. Okay, so everyone can hear. If you are not Mr. Piotrowski or in this room, mute your phone, please. So we don't wander into that again. All right, thank you. Mr. Piotrowski, please continue to exercise excellent patience in this and repeat your question.
I think my last question, Mr. Brown, was just to clarify that indeed the amount of the bonus payment to be made is not referenced anywhere in the lease or the attachments, right?
Correct.
Okay.
And just so I'm clear, that will be in the order.
In the lease, there's a reference to, in the first paragraph, well, let me ask you a different question. Is this, I mean, this is a form lease, obviously, but did Snake River or its predecessors use this same form in entering into the voluntary leases in this spacing unit?
Very, if not same, very similar.
Okay. And so, and just so that, my clients understand, if they become deemed leased, they will be subject to these same terms and conditions that the voluntary lessors have agreed to, correct?
Correct. And just for clarification, there was leases taken by 3 or 4 different outfits out here. So the lease form, word for word, I'm going to say they're very, very similar.
Now, there is also, Snake River has identified the intended site of the well in this tract, is that correct?
Yes.
And are there provisions for payments above the $100 bonus payment and the 1/8 royalty for the property owner whose land will be the site of the well?
We have a surface use agreement with the owner of the property that we're going to drill on.
At present, is there a way to move oil or gas from that location to some other location where it can be marketed?
Yes, there is. There's
And
a
what is that
riser,
method?
pipeline, and there's a riser on the pad, or where we have the surface use agreement. There's a riser on that surface use agreement.
Explain to me what a riser is, please.
It just rises up out of the ground. It's on the pipeline that goes to Little Willow, and the gas will go into, well, the product will go into the riser, and then the pipeline goes back under the ground and goes over to Little Willow, and then on from there to Highway 30.
Now, in paragraph 1, the actual numbered paragraph, I lost my place, so give me just a moment. Still looking at page 69, which is the first page of the oil and gas lease. Looking at paragraph 9. Paragraph 9 says that lessee shall pay for damages caused by its operations to growing crops on the premises. why are crops treated separately here from other types of damages?
I can't answer that.
Is there anything in this lease that provides similar protections to lessors if the lessee's operations cause damages to other aspects of their property interest?
Yes, and that would be in the addendum, paragraph 1, I believe.
Okay, so if we look at paragraph 1 in the addendum, it says the lessee shall take reasonable precautions to minimize adverse impact to lessor's farming, dairy, and ranching operations. Although farming, dairy, and ranching are certainly important elements of land use in Idaho, does that extend to the use of property for other purposes?
Yes, and if you'll go to the bottom of 1, it says lessee shall pay the surface owner for reasonable damages to growing crops, grass, buildings, livestock, feed, fences, and other improvements in personal property caused by lessee's operations.
Does anywhere in the lease or the addendum does the lessor take responsibility for losses caused to the lessees, or does the lessee take responsibility for any losses caused to the lessor's real property values as opposed to personal property?
I can't answer that question.
Are you aware of anything in this agreement that would provide that the lessee shall pay the surface owner for damages to real property as opposed to personal property?
I am looking and can't answer that question.
Since you've got the addendum in front of you, would you look down to paragraph 6, please?
Okay.
It provides for an additional 3-year term at $50 per acre. But why is a 3-year term worth $100 today, but only $50 3 years from now?
Can't answer that.
Would you agree to me that something that is worth $100 today is almost certainly going to be worth more than $100 3 years from now?
Can't answer that.
Are you familiar with the notion of monetary inflation?
Yes, I am.
Okay, so do you know of anything that you could buy for $100 today that you think you would also be able to buy for $50 3 years from now?
I know if we drill a dry hole out here, that that'll be worth a lot less.
In which case you won't be renewing this lease, will you?
Can't answer that. That a lot of things will happen in the next 3 years.
There is a provision in paragraph 8 which provides that if the operator or the lessee fails to make royalty payments on time, there shall be a 1% penalty for each calendar month. How did you arrive at the number 1% as a penalty for late payment?
I do not know. I would assume that if you multiply by 12, that's 12% per annum.
And is 12% per annum a number that, you know, is based on anything?
I've seen it in other contracts in other industries as a punitive measure.
Looking at paragraph 9, which is still on page 72, which is an agreement that the lessee, in this case Snake River Oil and Gas, shall indemnify, defend, and hold harmless the lessors from certain types of claims. And it is limited to claims caused by or resulting from any negligent or otherwise wrongful act or omission of the lessee. Would you agree with me that that is a limitation on the extent of SROG's liability?
I'm sorry, I got behind you. Which?
I'm sorry.
Can you repeat?
So looking at paragraph 9
Okay.
on page 72.
Yep.
And in that paragraph, it appears to me that Snake River Oil and Gas, the lessee in this agreement, is indemnifying its lessors for damages caused by or resulting from any negligent or otherwise wrongful act. Would you agree with me that that would allow liability against Snake River Oil and Gas only if its conduct was deemed negligent or otherwise wrongful?
I don't agree with that.
Okay. What do you understand would be Snake River Oil and Gas's liability then? Or what types of acts would it be liable for?
For our operations,
So if operations result in harm to any lessor, Snake River Oil and Gas would be liable?
via our operations related to physical damages. If we break
Okay.
it, we fix it. So we break it, we fix it, or we pay for it.
Okay, so if the drilling for oil and gas that's contemplated here occurs, and the fact that there is an oil well near somebody's property causes a loss in their property values, will Snake River Oil and Gas be responsible for that?
I think that's out of the purview here.
Are you willing to accept that liability on behalf of Snake River Oil and Gas?
No, that's not our business.
Okay, so there is a limitation on the liability that you are willing to accept, right? And I'm sorry.
You have to answer that one.
Yes.
And there are circumstances certainly imaginable in which lessors might suffer losses as a result of this agreement, and you would not be willing to accept responsibility for those losses, correct?
Objection calls for speculation.
Sustained.
I'm sorry, what was the objection?
More specific, please.
Okay. Mr. Brown, is it true that there are some losses that lessors might suffer as a result of oil and gas operations occurring in proximity to their property that Snake River Oil and Gas would not be willing to bear responsibility for?
Objection calls for speculation.
Agreed. Sustained.
What rule is, what rules are we applying here, Mr. Thomas? Because I don't think the rules of evidence apply.
Mr. Piotrowski, your line of questioning is speculative, and I would ask that you specifically ask that you ask specific points about the values you're wishing to discuss, specifically the exact values you're wishing to discuss, excuse me.
Okay. Mr. Brown, is it true that if oil and gas drilling results in an overall loss of market value to the property owned by lessors, that is not a loss Snake River Oil and Gas is willing to indemnify or hold lessors harmless for?
The same objection and also lack of foundation.
Mr. Christian, I think the question was specific enough. I'll allow it. Mr. Piotrowski, if you need to repeat that, you may.
I'm not sure I can repeat it, but I'll do my best, unless Mr. Brown heard me well enough to be able to answer.
The question is whether you think Snake River is responsible for diminution in value.
Don't think it exists.
But Mr. Brown, my question is, if oil and gas operations conducted by your company result in a loss in market value of the properties surrounding the well and within the integrated spacing unit, will Snake River Oil and Gas be willing to compensate for those losses?
And I don't think there is any evidence of diminishing property values. In fact, property values have all escalated in the area. And
That's not what I asked you, sir. I said, if there is a diminution, will Snake River Oil and Gas be responsible for it?
no.
Mr. Brown, if you would please, still in Exhibit SR1. Turn back, if you would, actually starting at now on page 1 is the actual application. And
Where are we?
hold on a second, I'm trying to find my place. Well, I didn't mark it, so let me.
Okay, SR1, the actual lease.
No, I'm sorry. SR1 is the whole application. So turn back to page 1 of SR1, please. Exhibit SR1 is everything, including the leases and the operating agreement. Well, maybe I can ask this question a little bit differently since oh, here we go. Yeah, if you would please turn to page 3. And looking at paragraph 9 of page 3, is a statement that says Rita Lochner, the owner of a 1-acre tract, was paid $250. Do you see that?
I do.
And to your knowledge, is that correct?
I'm aware that an owner of a 1-acre tract was inadvertently, and I'll have to defer to the landman. I think the landman's going to be on here in a second, but yeah, what it says, an erroneous departure by a landman or a broker for a 1-acre purchase.
But the result is that the highest bonus payment made in this tract was $250 to this one particular owner, right?
Yes, and I believe there was additional consideration, which I'll let the landman speak to.
So you're not familiar with the terms of that lease or payment?
Specifics as to that 1-acre, I'm going to have to defer to the landman.
So you don't know what happened there or how it happened?
Not really. That particular landman worked for the predecessor and hasn't been employed in probably 2 or 3 years. The field landman. So I'm talking, when I say landman, I'm talking about our employee Wade, who's going to testify next. But as to the gentleman who paid that $250 for that 1 acre, he worked for the predecessor, and I'll let him speak to that. I'll let Wade speak to this.
Have you reviewed the lease for that tract?
I have not.
Okay. So you don't know if that lease is similar to or different from the leases that you testified about earlier?
As to that 1 acre, no.
Okay. Thank you, sir. That's all the questions I have.
Thank you, Mr. Piotrowski. Ms. Vega, you may ask questions of the witness at this time. If you'd like to walk to the podium, Mr. Christian, if you wouldn't mind just stepping to the side. Thank you.
Good morning, Mr. Brown. Joy Vega with the Office of the Attorney General, counsel for the Department of Lands in this matter. I have a couple of questions just to clarify a few things about the JOA, which is Exhibit C to the application, and then also to cover one potential inconsistency in information sent out to potential lessors. And if that second question is going to be better answered by Mr. Moore, then just let me know. So looking back to Exhibit C, which is the JOA, Joint Operating Agreement, there are, skimming through this document, there's a number of strikeouts and additions through the whole document. Do you see those?
Yes.
And is it correct, we don't have in this application form, there wasn't an actual copy of an actual signed JOA that Snake River has with a working interest owner, is that correct?
Correct.
So have you had the opportunity to look at an actual signed, enforceable JOA and compare that with the strikeouts and additions to this Exhibit C?
I have to say that I have not personally set these side by side.
Is there has Mr. Moore or anybody else in your employee group? Or I guess a better question is, do you know who prepared the strikeouts and additions?
Let me, Mike, I would have to defer to either Mike or my partner. I can't answer that.
Would it be your expectation that the strikeouts and additions would be materially the same as current signed JOAs?
I'm almost certain that they're identical.
Also, in Exhibit C, primarily in pages 49 through 55, which is actually an exhibit to the exhibit, so it's the COPA exhibit.
Okay, the exhibit to the JOA?
Correct. Exhibit C to the JOA, which I believe starts on page 49 of the Snake River's exhibit.
Okay.
So throughout these pages, there are numbers that are added. So for example, on page 5 of that Exhibit C, paragraph B, it says, for example, procedure can be amended by an affirmative vote of 2 or more parties, one of which is the operator.
I need to get with you, so.
Here, actually. May I approach the witness?
Please.
So, looking at,
Okay, you and
so-
Copus?
yeah, the COPA.
Okay. Okay, there we go.
There we go. And so throughout the COPUS, there's numbers inserted. So for example, on page 55 of the exhibit, there's some numbers, where it says if the operator absorbs the engineering, design, and drafting costs related to the project, there's percentages, so 5%, 3%, 2%. You see those? Is it your expectation that these numbers that have been inserted are materially the same as existing signed JOAs?
I would venture that they're identical.
Thank you. Mr. Brown, I believe you previously testified that it's your understanding that that through prior integration procedures done by Altamisa, or AM Idaho LLC, that there was no working interest owner, that there was no integrated owner who elected to be a working interest owner. Do you recall that testimony?
Yes.
Were you in the timeframe of, say, 2014, 2016, were you involved in Altamisa's integration application efforts?
I was a very involved partner, so yeah, I was pretty knowledgeable.
Do you recall if during that timeframe, this company known as Trendwell actually elected to be a working interest owner in one of the integrated units?
I didn't think they had. I don't remember can you recall which unit they were integrated in?
I don't know.
Yeah, they drilled a well. They operated a well themselves, but I don't recall them. I don't recall them being a partner in any of our wells, and I don't recall them participating via an integration.
Is it your experience that residents of the area, whether they own commercial properties or residential properties, have not opted into being working interest owners through the integration process?
That is correct.
One question, just to clarify, perhaps an inconsistency in the application, and this is a question that perhaps is better for Mr. Moore, but just let me know. So Exhibit F to the Snake River's application is it's a form cover letter to mineral owners that I presume was sent with Snake River's offer information for leasing. Is that law? Have you gotten to Exhibit F?
Yes.
And are you familiar with this document?
I am.
And have you seen this document prior to today?
Yes.
And were you involved in kind of the drafting of the information that was presented in this cover letter?
I didn't draft, but I was familiar.
And it's in fact presumably was signed by Mr. Wade Moore, correct?
Correct.
So in the middle of Exhibit F, there's 4 bullet points, and the last one says option to extend the primary term for 3 years at $100 per net mineral acre. Do you see that?
And I was actually going to mention that here in a sec. If we've got a typo in the body, if this needs to be amended here to say 100, Mike, you good with me retroactively? Let's just.
Well, let me ask you a question.
Yeah.
So your previous testimony, talking about the form lease, and I believe it's Exhibit A, so that form lease,
and
but there's
we've got a typo there. Go ahead.
That there's a $50 extension payment.
That should be 100.
Okay, so between these 2 documents, the offer made in this cover letter to mineral interest owners would be the correct amount.
Correct. So as to me, Mr. Piotrowski's question, that should say 100 on the option to extend.
believe that is all of my questions. Thank you.
Thank you. Thank you, Ms. Vega. If everyone just grant me a little bit of time as I update my notes here. Mr. Christian, of course, you can walk up. Snake River have any redirects for this witness?
Yes, Mr. Administrator, thank you.
Please.
Richard, Mr. Piotrowski asked you about the reference to consideration at the beginning of the form of lease where it says $10 and other adequate consideration. Recall that?
Yes.
Typically, is the bonus check delivered to the lessor at the time the lease is signed?
Yes.
So, in fact, there is other good and sufficient consideration delivered to the lessor in the form of whatever the bonus is agreed upon at the time the lease is signed.
Yes.
And, Mr. Piotrowski asked you some questions about whether Snake River would be responsible for diminution in value of surrounding properties. You recall that?
Yes, I do.
Are you aware in your 40 years of experience as a landman and otherwise in the business of any lease in which you, Wise Brown has participated, or that you participated in as a landman, where the lessee / operator has agreed to pay a lessor's diminution in property value?
No, I'm not.
The typical approach is to pay for damages to surface elements, right?
Correct.
And in this case, that includes, for example, buildings. And buildings are part of the real estate, correct?
Yes.
Ms. Vega asked you about the form of JOA. Wise Brown has a couple of staffers in Arkansas. Chad is one, Royce is another. Can you tell me their full names?
Chad Rader, Royce Dixon, Nathan Caldwell.
Would either Chad or Royce been involved in preparing the form of joint operating agreement?
Yes.
Do you recall any conversation with them and along the lines of preparing a form which tracked with the form in use by the working interest partners?
Ask me that again.
Do you recall instructing or having conversations with either Chad or Royce about preparing a form of joint operating agreement for this application in a form that tracked with the one that Snake River has with its working interest partners?
I just don't recall.
Okay. I think it's all the questions I have.
Thank you, Mr. Christian. Turn this away a little bit so I can read my notes. Mr. Brown, I've got 2 questions for you as well. Mr. Brown, I don't want to inundate you too much, but I do have a few. The application states drill site is leased. First, how would you define drill site as it is used in Idaho Code 47310? Is that referring to the surface location or to the entire wellbore?
When you say wellbore, I think the wellbore going down in the earth, so ask your question.
So is the drill site isolated to the surface location? Or is the drill site also part of the wellbore to TD?
When I think of drill site, I think of the surface location.
Okay,
Covered by the surface use agreement.
Thank you. The application states that the well site is in southwest quarter of section 11. I think it changed from the application of this stated from southeast quarter of section 10 anyhow. Do you know more specifically what the well site's going to be?
Yes.
Could you share that?
Yes, we negotiated a surface use agreement with Fallon Enterprises, who's they own about almost 1,000 acres in the area, and predominant to this unit, and we negotiated 3 or 5 acre, I can't remember, surface use area agreement with them.
Okay, as a follow-up, and again, I don't expect you to have coordinates, but maybe Wade could provide those or something so we have an idea exactly where that well's going to be.
And it's in the southwest of 11. It's just about, I can't remember, Wade will know the footages north of Killebrew Road.
Thank you, Mr. Brown. Should this order allow for the assignment or change in operator with a different process than is outlined in statute?
Can you ask that?
Are you asking that we allow for a different process other than statute when moving from one operator to the other?
I don't.
Okay, thank you. Snake River's application states that drilling activities will not occur on lands to be integrated. What does this include? Does it include the well bore passing underground?
Okay, I'm thinking through your question.
So drilling activities,
Yep.
let's start there. What are drilling activities?
Drilling activities, drilling the well to TD.
Okay, thank you. Does that include the well bore passing underground? You just enumerated it, I believe. Yes, drilling activities include the well bore.
Yes.
Okay. Will this well bore pass underground through unleased lands?
I can't answer that.
Okay, thank you.
Wade,
And again, thank you. The questions that I put to Mr. Brown are just as easily, I'll ask Mr. Moore of them as well, okay? Is there going to be additional surface use proposed beyond the well pad?
not at this time.
For example, a road, an access road, or anything along those lines?
I think we have a 200-foot road north of Killebrew, which is approved by Fallon Enterprises to access these, I think it's actually to access the surface use agreement.
Thank you. Are those on leased properties? Are those on leased properties?
Yes.
Okay. I'll hop down a little bit more. Do you think it's appropriate for the integration order to deem mineral owners leased under every term and condition in the lease?
Yes.
Can you expand on that?
I don't know if there is any, so the question is, are they to be, if they're determined deemed leased, then are they subject to all the terms in the oil and gas lease attached? And I would say yes.
Okay, thank you.
With the exception of the change, the option period, or the option to 100 an acre that we just talked about.
Thank you. Some additional questions. What time limit do you propose placing on development of this unit? How long? I mean, is it going to be a year, or just tell me a little bit about that?
We would like to proceed with this as soon as possible, within 45 to 90 days.
Are you proposing that the integration should continue indefinitely?
Yes.
Thank you. What's Snake River's view as to drilling additional wells on this spacing unit?
We would certainly hope to drill additional wells, given encouragement.
Have you noticed any of the mineral interest owners that there could be additional wells drilled?
It's provided in all of the lease agreements, and I would assume when we negotiated the leases, that the landmen shared that there's potential of additional wells.
What process, thank you, what process will Snake River use to request additional wells?
It would start with notification, application to Department of Lands we would have to fill out a pretty lengthy application to drill, which is, has a public notice period, and we also have to get county permit.
Thank you. Could this integration order be restricted to one well? Why or why not?
I don't see how it could be restricted to one well, because that's not what we're applying for, and I don't think that's what's been determined is what the integration orders previously have stated, or envisioned, excuse me.
Thank you. What's a reasonable charge for the supervision and interest of this, broadly? And if you don't,
I'm sorry?
I said, what is a reasonable charge for the supervision and interest in this application? You may be calling on your experience in other states.
You say supervision of this application.
Right.
On the regulatory side?
Right.
I'd have to defer to my partner, Chris, because he sits on the Oil and Gas Commission in Arkansas. I don't remember what the rates are, but we can get that.
Thank you. That's good. All right, those are all the questions I have for you, Mr. Brown, right now. Mr. Christian, you may call your next witness.
May I ask a couple follow-up questions?
Sure, go ahead.
Thank you. Just for purposes of clarity, maybe. Mr. Brown, I don't know if you know the answer to the question, but is your expectation that the well that you anticipate drilling in this unit will be vertical or deviated?
I'm having a senior moment.
Okay. Can't remember.
No, Wade can, I know, we've got so much going on, I just have it.
But you anticipate submitting an application for permit to drill as soon as the order in this matter is issued?
Correct.
Okay. There is another unit in which, integrated unit in which Snake River has applied for and ultimately received approval to drill a second well unit, correct?
Correct.
The Barlow, section 14.
Yep.
And the reason is that the well targets a second source of supply, right?
Correct.
That's all the questions I have.
Thank you, Mr. Christian. Out of courtesy, Mr. Piotrowski, if you have any brief follow-up questions, you're welcome to.
I do, thank you, sir. Mr. Brown, as you sit here today, there's the possibility that there are additional pools of hydrocarbons overlaid by this spacing unit, right?
Possible.
But we don't know where those are, do we? Or even if they exist, right?
Correct.
And so as we sit here at the moment, there's no way to know if such pools are found where the appropriate placement for a well might be, right?
Correct.
And no way to know what nature of, drilling, whether vertical or horizontal or otherwise, might be appropriate to reach this as yet unidentified pool of hydrocarbons, right?
Correct.
So it's fair to say that there could be something down there. We could decide at some future date that it's worth drilling for, but beyond that, the details are just unknowable, or at least are unknown right now, correct?
Correct.
Thank you. That's all.
Thank you, Mr. Piotrowski. Courtesy to the department. Ms. Vega, do you have any additional follow-up questions?
Just one, thank you. And if I may, this question goes back to your earlier testimony. There was some discussion about the gathering pipelines and the infrastructure that's in place to move hydrocarbons to the processing facilities. Do you recall that discussion?
Mm-hmm.
Is that a yes?
Yes, I do.
And are there access and or use agreements with the owners of the pathway of that pipeline in place?
Yes, we have a right-of-way extends from the Fallon 110, and it goes basically in an eastward path, and it passes by this wellbore. I described that riser that's on this SUA and goes to Little Willow over on Simplot in Little Willow Field.
And Snake River has permission from all those owners
Yes.
along that pathway?
Yes, we do.
And is my understanding correct that the Idaho Public Utilities Commission is one of the primary regulators of that pipeline?
Yes.
Thank you.
Thank you, Ms. Vega. Mr. Christian, you will have the opportunity to call your next witness, but right now, it's approximately 10:43 Mountain Time. Let's take a, let's say 15-minute break, if you all don't mind. Chris, please pause the recording. I believe our phone's unmuted and you're shaking your head yes, which means you're hearing us, and that's awesome.
Yep, the recording's been unpaused.
Thank you, Mr. Gozo. Mr. Christian, you may call your next witness.
Thank you, Mr. Administrator. We'll call Waymore 3.
Mr. Moore, are you on the phone?
Yes, sir, I'm here.
Great. I'm going to offer the oath to you. Do you swear or affirm that the testimony you will give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, Mr. Christian. You may proceed.
Thank you. Mr. Moore, can you state your full name for the record?
Wade Moore the third.
And what is your job title?
Landman.
And are you a landman for Snake River Oil and Gas?
Yes, sir.
And working here in Idaho?
Correct.
Have you been, at least in the last couple of years, responsible for Snake River's leasing efforts in the spacing unit that is the subject of this integration application?
Yes, sir, I have.
Does that include both you personally contacting landowners and you managing contract brokers?
That is correct.
You have the integration application materials, which is Exhibit SR1, with you.
Yes, I do.
Can you please look at Exhibit E to the application, which is the resume of efforts, beginning on, I believe it's page 73 of the application.
Mr. Christian, I'd like to speak in real quick. Mr. Moore, if you would not mind, please, as you speak, since we're all over the phone, and this is being transcribed, in your answers, would you please articulate and maybe even speak a little bit slower so that we can all get a good understanding of what's going on? And it's something I deal with as well, so we're one party here, but let's just make sure we speak clearly as we go through this, okay?
Yes, sir. Thank you.
Thank you. Go ahead, Mr. Christian.
Thank you. Wade, do you have Exhibit E to the application in front of you?
Yes, sir.
That is the resume of efforts made to contact uncommitted mineral interest owners in the subject spacing unit.
That is correct.
Were you responsible for preparing this resume of efforts?
I did.
And does it identify all of the uncommitted mineral interest owners in the unit?
Yes, sir.
There is, Mr. Brown, I think testified to this, but there is one owner who has since been leased, correct?
That is correct.
Is that the Mussers?
Yes, they did lease.
And that is at least on the resume of efforts, that's track number 2.
That is correct.
Okay. Did you personally direct at least 2 contacts with each of the uncommitted mineral interest owners in the last 2 months before the application was filed?
Yes, I did. It's been and longer. Yes.
Okay. Can you generally describe what your efforts were?
Recent efforts, aside from the efforts that were a couple years ago, the recent efforts started in around December of 2020 and carried on for about 4 months until April.
Did they include in-person and mail contacts?
Attempted in-person and mail contacts.
There were some owners where you attempted to make contact in person and were unable to?
Yeah, a lot of non-response, either by phone and mail, showed me not interested in communicating.
Some of the efforts listed on the resume of efforts go back further to the time period of the previous operator, is that correct?
That is correct.
But generally, it reflects that these owners have all been contacted multiple times over the last few years.
Yes, that's correct.
And your mail contacts included the offer letter, which is Exhibit F to the application, is that right?
That is correct.
There's been some discussion of this, but with one exception, the highest bonus offered or paid in the unit was $100 an acre, is that right?
That is, yes, that's right.
The exception is Rita Lochner's 1 acre tract.
Yes, that's the exception. Yes.
Do you have any personal knowledge of how that particular $250 an acre payment came to be?
I do not have personal knowledge. No, I was not responsible at that time for that leasing effort.
Does Ms. Lochner own a company that owns other acres in the unit?
Yes, she Donahoe Rock and TD Rock.
And are they both, they're both leased?
Correct.
Now, were they leased at $100 an acre?
They were $100 an acre. Yes.
And to your knowledge, is any voluntary lease in the spacing unit at greater than a 1/8 royalty?
There is not.
The resume of efforts, which is Exhibit E to the application, reflects just over 90% of the mineral acres in the unit leased. Does that track with your knowledge of leasing efforts?
Mike, I didn't catch your full question. I apologize. Can you repeat?
The resume of efforts reflects a percent lease of just over 90%. Is that accurate to your knowledge?
That is accurate. Yes.
The lease that was taken since the application, the Musters, can you tell me what the bonus and royalty and lease term were for that lease?
Mustard was paid $100 per acre and a 1/8 royalty.
And what was the term?
5 years primary, 3-year option.
Okay. There's been some other discussion of this previously, but the proposed well site in this unit is going to be on Fallon Enterprises land, is that correct?
That is correct.
And is the anticipated well going to be directionally drilled?
To my knowledge, it will be a directional drill.
And is it generally, is the anticipated path of the well more to the south from the well path?
As my understanding goes, that is correct.
And is it your understanding that the anticipated path of the wellbore will cross land that is all currently leased?
Yes, sir.
Can you look at your declaration weight, which is Exhibit B to the application?
Okay.
I'll direct you to, first of all, have you reviewed the declaration?
Yes, I'm there, Mike. I'm ready.
Okay. Is there anything in that declaration that has changed in your knowledge since the time you signed it?
No, sir. Other than the muster, I'm reading it right now. If it doesn't identify individual names as far as being leased, that's the only thing that changed was we picked up another lease. So other than that, no, nothing's changed.
And is the discussion in paragraph 7 of your declaration regarding the factors behind the suggested risk penalty, are all of those facts still true?
To my knowledge, yes.
I don't think I have any other questions.
Thank you, Mr. Christian. Mr. Piotrowski, you may ask questions of the witness.
Thank you. Mr. Moore, do you still have your declaration in front of you?
Yes, sir, I do.
And in paragraph 4 and 6, you say that in both those paragraphs, you say that nobody received more than $100 per acre, but you also just testified that one person did receive $250 bonus payment for a 1 acre lot. Correct?
Paragraph 4 says for tracts over 1 acre,
Okay.
$100. Then, which we have, disclosed that one that is exactly 1 acre, which was paid $250. Correct.
Okay. Mr. Thomas is waving to me. I'm not quite sure why.
I'm sorry, are you waiting on me?
I'm not sure. Can I proceed, Mr. Thomas? I'm not sure that Mr. Thomas can hear me.
Okay.
Hold on, please.
Do we still have audio? Are you able to hear me?
I'm able to hear you, Chris.
Chris, I'm not hearing you either. I have a problem. We may have lost the line. here.
Okay. I can hear you
Let's see what I
now.
can do
You've
on
got
our
your,
end. And Mr.
okay.
Pietrowski, I'm sure it was quite eloquent. Please, please hold that thought. Yeah, as I'm looking at this, I think this phone kicked off. And I just unmuted Zoom so that we could, tell them. Let's see what I can do for us.
The number you have dialed has not
It's
been.
because I was trying to get it plugged in. 900-633.
Welcome to Zoom. Enter your meeting ID. Enter your participant ID followed by. Please enter the meeting passcode followed by pound. You are in the meeting now. There are 9 participants in the meeting. This meeting is being recorded. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting.
Chris, let's do a test.
Okay. I think I can hear you now. I think you're back on. Can you hear me?
Very good. Yes, very good. And I would say to all participating via Zoom, let's maintain eye contact when we can. All right, just in case that happens, we just start using pirate signals. So, good, excellent. Mr. Pietrowski, please start over with your questions of the witness, and thank you for your patience.
Thank you, sir. Mr. Moore, the point I'm trying to get at is merely that there is a lease that included a bonus payment of $250 for a 1-acre tract within this spacing unit, correct?
That is correct.
Okay. And all of the other leases were at $100 per acre, correct?
That is correct.
And $100 for all tracts under an acre.
Yes, sir.
Okay. And the one exception is the one tract that received a $250 bonus payment on a 1-acre tract, right?
That is correct. Miss Rita Lochner. Correct.
Okay. Is there any way at the moment to estimate the value of the royalties that the lessors are likely to receive if and when this well is drilled?
I'm not the person to try to even guess at that. I'd have to defer to a reservoir engineer. No, so to answer your question, no, I can't do that.
Okay. And so in entering into these leases, did you make any statements to the potential lessors about what they could expect to earn in royalties?
I personally did not, no.
Thank you. That's all the questions I have.
Thank you, Mr. Pietrowski. Ms. Vega, you may ask questions of the witness.
No questions.
For the record, Ms. Vega did not have any questions to ask of the witness, and I only mentioned that to make sure we get it recorded. Does Snake River have any redirect for the witness?
No, sir.
Okay, thank you. I do have some questions. Mr. Moore, some of these questions I've asked already of Mr. Brown, so I'm just asking you for clarity, and you may have the additional information. First, you know the location of the well to be drilled?
I know, yes, the surface location. Yes, sir.
Mr. Moore, the application says that operations may be similar to operations found at the previously drilled and completed wells in the Little Willow area. Can you describe in more detail what those similar operations may be?
I'm not able to describe, I'm not privy to operational function. No, sir.
Okay, thank you. Mr. Moore, regarding the application mentions gathering lines, will those gathering lines be placed on an uncommitted owner's property?
Currently, the answer is no. It's from the, where the well pad will sit, it's on a leased ground. And our connection point for that well is about 100 feet away on the same leased ground. So, no, sir.
Thank you for that answer. Can we include a condition in the integration that states that?
I don't know if I can give you the directive to do that, but my opinion is that it would be okay to do so.
Thank you. And to bring up the $250 bonus payment again, albeit briefly, can you confirm on the record that, well, excuse me, let me go back and make sure we cover this. The statute does say in 47.320 that there's the affidavit stating the highest bonus payment paid to a leased owner in the spacing unit be integrated prior to filing the integration application. There's no exemptions for erroneous departures. Mr. Moore, I'd like you to confirm that this rate, confirm this $250 rate for the record for me as the only evidence we have right now for this application.
Yes, sir, that is correct.
My questions one more time.
Did you hear me?
Yes, I did. Thank you, Mr. Moore.
Okay.
Mr. Moore, one of the reasons the application gives to requesting a 300% risk penalty is that this is a wildcat area. Is this truly a wildcat area, given the Barlow 114 well that's drilled nearby?
Again, based on my knowledge of oil and gas experience, and I would say yes, because there's really not much production to base our understanding on as far as the geologic of this field. As a landman, you know, again, my best answer is going to be yes, it is, due to the lack of production. Let me say this, proven production.
Mr. Moore, in your opinion, at what point is something is basically a field, or at least a well site, no longer a wildcat well?
Oh gosh. Again, you're having a landman answer this kind of question. You know, I'm gonna have to say, as far as proven production, if you get 10 years of proven production out of one area, constant proven production, I think you'd probably be out of the wildcat phase. That's just my, again, Mr. Thomas, that's my opinion. I don't have any basis of that.
Thank you, Mr. Moore, that's adequate. Mr. Moore, I want to ask you a few questions regarding reaching out to folks, and I think that's more in your purview. Some of the attempts to contact owners occurred when the application did on December 28th, with the second occurring on February 25th, specifically the River Ridge Estates and the Larsons. That is 56 days between contacts, which is less than the 60-day required statutes. Was there any contact attempts made after February 25th? We have one entry that says March 24th, no response to offer.
Right.
Was there a contact then, or just a confirmation that the owner had not contacted Snake River?
No, there's another contact.
Please say that again for me.
It was an additional contact.
There was?
Yes. Sorry about that. Yes.
Okay, there was, yes. Thank you. Last question. Mr. Moore, I see that the prior operator's efforts are included in the resume. Should the attempts the prior operator made to reach an agreement with mineral interest owners be considered a separate occasion to inform the uncommitted owners of the applicant's intention to develop a mineral resource in the proposed spacing unit? And the crux of the question is, should the attempt made by the prior operator be considered a separate occasion?
Probably yes. I mean, I don't know how to answer that. I mean, it's the same landowners have been attempted many times, whether we want to say it's separate or not. I don't know how to answer that.
You did a good job. Thank you, Mr. Moore. I appreciate it. I don't have any additional questions at this time for the witness. Counsel, if you'd like to redirect.
I don't have anything further, thank you.
Thank you. Counsel, you may call your next witness.
That is our last witness.
Okay, very good. Thank you. In that case, Mr. Piotrowski, do you have any witnesses you would like to call?
We have no witnesses to present.
Thank you. Ms. Vega, do you have any witnesses you would like to call?
No, thank you. However, if I may, not a witness, question. Pursuant to the pre-hearing order, the Idaho Department of Lands did submit an exhibit, IDL 1. I had received word from Mr. Christian that he would stipulate to the admissibility of this exhibit. I didn't hear from Mr. Piotrowski, but are you wanting the department to prove up this exhibit or to provide information about it?
Well, let's start with, while we're all here, Mr. Piotrowski.
I have no objections to that exhibit.
Thank you.
Not an offer, it's just really demonstrative for the use of you as the administrator, demonstrative of the field and the different administrative matters that have taken place since 2015.
Thank you, Ms. Vega. I certainly admit the exhibit. I appreciate that. Well, folks, since the witnesses are finished, the parties may now offer closing arguments. I'm not putting a hard limit on these closing arguments. Tentatively, I'd like to go under 20 minutes, but we're far enough ahead in the calendar that each can talk as they need. Snake River, you may make a closing argument at this time.
Thank you, Mr. Administrator. As a housekeeping matter, I don't know that I formally moved the admission of Exhibit SR1. to the extent necessary, I'll do so. I think the administrative rules are fairly flexible on that point, but I would move its admission. Multiple witnesses have testified their knowledge to it, and it's been on the docket for months. So I suppose if anybody else has any objection to it, we can discuss it, but.
Thank you, Mr. Christian.
One second. So, Mr. Administrator, I don't have a lot to add as commentary for the closing, other than to say, Mr. Brown and, in particular, provided testimony regarding, the key proposed terms and conditions of integration, which are not provided for by statute, which in this case would be the lease, form of lease and the form of joint operating agreement, and the bonus to be paid into the lease. For each of them have established that they are consistent with industry standards. Mr. Brown testified that his 40 years of experience in the industry, and that both of those forms have been used throughout his experience in many states. He testified to establish that they are consistent with terms previously accepted or rejected by courts or other oil and gas administrative agencies, specifically in this case, the use of the form of JOA in previous integrations, and the use of the form 610 generally by the state of Arkansas, apparently in all integrations, and applicable to the unit and its operations, and similar to other agreements within and nearby the unit. Mr. Brown testified that the proposed form of lease in particular was similar, very similar to other voluntary leases, both within the unit and in surrounding areas, in terms of its form and bonus, royalty, and term. There was not any contrary testimony or evidence provided by the objecting mineral owners to establish that there was a reason for a different term or condition to be appropriate. There was no testimony or evidence established that other terms and conditions should be offered, other than I think the suggestion by Mr. Piotrowski that, at least indirectly, that an operator ought to be responsible for diminution of property value. On that subject specifically, there was no evidence offered to get beyond speculation that any diminution of property value could occur or would occur in the future. And in fact, the testimony of Mr. Brown was that in his 40 years of experience in the industry, no lessee includes such a term in their lease, voluntary leases. There was no other evidence or testimony provided that the proposed terms in the application, including those addressed to drilling, equipping, and operating the well, are not either consistent with the act or that there are additional conditions necessary given the specific conditions of this unit. There was testimony about how the drill site and the wellbore will physically occupy property within the unit, and the testimony was that it will all be on the land of voluntarily leased owners. To the extent there may be any future use of the uncommitted owner's surface estate, there was testimony from Mr. Brown that the lease provides surface owner protections in the way of compensation for surface damages and indemnity for potential liabilities. And of course, Idaho Code 47334 remains out there. There's no testimony or evidence provided by any party that additional bonding should be required. And there was testimony from Mr. Brown that the proposed forms do not limit integrated owners that do not choose to participate from pursuing any private right of action they may have against the operator of future arms. So for those reasons, we submit that the terms of integration that are proposed in the application are just and reasonable and in accordance with the factors set forth by the administrator in his previous order, and that the application should be granted.
Thank you, Mr. Christian.
Thank you.
Mr. Piotrowski?
Thank you, Mr. Thomas. In your earlier ruling, you had indicated already there would be no opportunity to seek additional compensation. And I took that ruling at face value, that the compensation terms of this were set by statute, and there was not much point in even suggesting different terms, so we haven't done so. That said, what Snake River Oil and Gas requests of you is that for $100 and 1/8, it should be permitted to drill as many wells as it can justify in this spacing unit, in both this proceeding and any future proceedings it may bring. That the integration order will provide $100 an acre and a 1/8 royalty, whether there is 1 well, 2 wells, 10 wells, or 200 wells. That is neither just nor reasonable, and no set of other terms could make it just or reasonable. The fact is that the integration order should be denied because the law, as currently established in Idaho by the commission and by the department, prevents landowners from getting the fair value of their property. I know you'll disagree, but that's our position, and on that basis, the department should deny the application.
Thank you, Mr. Piotrowski. Ms. Vega, would you like to make any closing arguments? Again, just out of convenience, Ms. Vega and the department are not providing closing arguments. Following my notes very well here. Snake River, if you'd like, you may provide rebuttal at this time.
Short rebuttal, Mr. Administrator. In fact, there is abundant evidence in the record establishing fair value. Mr. Brown testified at length, and as did Mr. Moore, that every voluntary lease in this unit and the vast majority of voluntary leases in the area are at a 1/8 royalty. That's the market. Likewise, with the one exception of Ms. Lochner, and granting, the statute says what it says, every voluntary lease in this unit and in the surrounding area is at a $100 level. And Mr. Brown testified that the form of lease proposed is consistent with the form used with many other lessors in the unit and in the area. So there is, in fact, evidence, substantial evidence in the record establishing the market value for a lease of minerals in the area. That's all I have. Thank you.
Thank you, Mr. Christian. I would like to put out a thank you all for coming today. We will have a public comment period in this hall tonight at this location at 6 p.m. I'll be here. Maybe the only one here zooming in. Could be very brief, but anyone is welcome to come and provide public comment at that time. However, for this proceedings, it is now 11:34 a.m. Mountain Time, and the hearing is concluded. I will take this under advisement and issue a written order. Thank you, everyone, for your participation today. Chris, you can pause the recording at this time.